Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wassalatu wassalamu ala Sayyidina Muhammadin ashrafil anbiya wal mursalin. Wa ala alihi wa sahbihi ajma'in. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Salam sejahtera and welcome again to our live lecture. In a short while, I'll try to, because I think the contrast of my video is so bright. Let me just switch off certain light so that you can see me clearly. Give me a couple of seconds. Right, I'm back again. Can you all hear me? Give me some sign that you can hear me well. Okay, no sign from my student. Okay, thank you very much for that heart that you gave me. Okay, how's the quality of my video? Okay, you can always use the chat box if you want to say out something. Right, so far 45 students is in the classroom. I do think that I have approximately around 30, almost 80 students. So more is yet to come in. All right, thank you very much for joining this live lecture. All right, and before I continue, two things that I need to raise. Do subscribe to my YouTube channel. Okay, you can enjoy more video. Okay, that I share on the channel. And secondly, once you are in the live session, please sign your attendance via YouFuture. All right, that's something that the responsibility is on you. Okay, to sign your attendance. And here I need you to be truthful. If you are here in this live session, then you can mark your attendance. And if you are not, please do not mark your attendance as present. Okay. And if you have any excuses for absenteeism, okay, you may upload the necessary MCs, time slip, or whatever letter of approval that allows your absenteeism in this session. Okay, please upload on your future. I will not be actually keeping those letters, MCs, as well as time slip. Okay. Right, what shall we do today? All right, as the title, okay? Today we're going to talk about one of the element among the important elements of a contract. Without this element, an agreement cannot be a contract. And this element is what we call competency. Right, I suppose most of you or all of you have your Contract Act 1950 with you. I would certainly love you to refer to the provision that I'm going to raise or I'm going to mention in this session. Right? So, are you ready? Give me a sign that you are ready. Right? You can always use the live chat. Thank you if you want to say anything. But so far, okay, as long as you give me some icon to show that you are there at the end of the line, I would actually appreciate that so much. All right, thank you very much. All right, live did not, sorry, YouTube Live has no gift for you to give me, but I'm sure that your responses would actually help me in the rating of this video session. Right, let us continue. Okay, so okay, I will prefer you to refer to section 10 of the Contract Act 1950. Right? So if you have with you, okay, the Contract Act, Section 10, subsection 1, let us read the provision together. Because in this provision, there are a numbers of principles as regard to competency. Right? So Section 10, subsection 1 provided that all agreements are contract if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. So there are a number of points or elements there. Okay, we shall be looking that into those elements at one point of time. Although that at this point of time we just want to we want to focus on parties' competency. So if you look at that section, it says that a contract is an agreement if it is made, one, by free consent of parties, two, parties who are competent to contract, three, for lawful consideration, four, with lawful object, and five, are not hereby expressly declared to be void. Right? We shall look at, as I mentioned just now, the element of free consent, lawful consideration, and lawful object, and not thereby expressly declared to be void. Okay, later at some other point, okay, of time. But as I mentioned again, and I mention it again now, that now we want to focus on competency of parties, right? So competency simply means the ability of the party to enter into a contract. And when is a person competent to contract? Okay, Section 11 of the Contract Act makes such a provision. Okay, now I want you to refer to Section 11 of the Contract Act. It says that every person is competent to contract who is of the age of majority according to the law which he is subject to, and who is of sound mind and is not disqualified from contracting by the law, by any law to which he is subjected to. All right. So it is very clear from this provision that there are three elements that will make a person competent to contract. Okay. First, he must be a person who has attained the age of majority under law to which he is subjected to. So that is what we call capacity in term of age. Second, he is of sound mind. That is capacity in term of his soundness of mind or mental capacity. And third, he is not disqualified to enter into a contract. All right. So that is what we call legal capacity. So when one talk about the capacity of a person to enter into a contract, these are the three main considerations. One, that he had attained the age of majority. Two, he is of sound mind. And third, he is not disqualified by any law from entering into a contract. Okay, so today we will try to look at all of them, if not at least, as we got to the age of majority. Right? So let us look at now the first competency, which is age competency. Okay, in Malaysia, just like any other country, we have a statute, we have a written law, that prescribe the age of majority. Okay, and the law is the Age of Majority Act 1971. Okay, this is an act passed by the Parliament in 1971 to determine what is the age of majority. Okay, all right. This will differentiate a person who is of the age of majority and a minor. Okay, so according to Section 3 of the Age of Majority Act, the age of majority here in Malaysia is 18 years old. Okay, how the law come to this number? Supposedly, probably the people who are expert in this area would know or understand that at that age a person is able to understand what he does, and he also understand the cause and effect to what he did. So when you understand what you are doing, and you also understand the cause and effect of what you did, you are said to be a person who has attained the age of majority, or in bahasa Malaysia, umur dewasa. And 18 years of age is the number that makes a person of the age of majority. He has become an adult at the age of 18 years old. Thus, okay, if he had not attained the age of majority, okay, he is not 18 years old, okay, on that particular day, okay, upon which he was born, okay, he is considered as a minor. Another word to describe a minor is an infant. Okay, a minor is a person who is incapable of understanding what he did or to understand the cause and effect of what he did. Right? So conceptually, a person who is minor does not understand what he is doing, or he does not understand the cause and effect to what he had done. So basically, he should not be made responsible, okay, for anything that he does. So basically, a person who is a minor is not a person under Section 11 of the Contract Act 1950 contract. So a minor is not competent to contract. All right. So are you all a minor? I suppose not. Okay, you have attained the age of majority years ago. Probably most of you are between the age of 20 or 21. So you had attained the age of 18 years old, meaning that you are not a minor. From now on, anything that you did, okay, you understand, okay, what you did, and you understand the cause and effect of what you had done. So you should be personally liable for your own act. No one is liable for your own act except for yourself. Okay? The same goes if you enter into a contract now, since you had attained the age of majority, okay, you had satisfied Section 11 and you are competent to contract. Okay, do you understand that? Okay, should I give further elaboration on that? Or if you want further elaboration, you can always ask me. I'm using the live chat, as well as you can give me some sign that you are at the end of that line there, at the end of the other side of this monitor, okay, or my monitor, then you are enjoying this live lecture. All right? Do you understand? Okay, all right. Thank you. One, two. Only 2% responded. Three, four, five, six. All right. Thank you. I'll accept that. Okay, the number of audience is fluctuating between 70 to 73. Okay, may I know anyone from you, okay, your the audience or the viewer, not from group BA 16, 17, or 18? If you are not, you can actually use the live chat to state from which group that you are in. Okay, or if you are not a full-time student, okay, you can use the chat box, okay, for to notify me. At least I know who are my audience, and I would actually deliver my lecture in accordance to the level of understanding. Okay, anyone? Okay. Mm, no response, I suppose. Okay. Right. Okay. I have my first challenge with technology. Something just came out on the screen saying that my connection is unstable. Okay. What to do? Okay. I've tested my hardware, I've tested my software, and I've tested the Wi Fi connection at the place I'm conducting this live. It was okay, but I suppose these are the challenges that we all have to face. Okay. Okay. Let me continue. Do you want me to continue, or you just me to just keep quiet, or whatever you want me to do? That I will actually uh, fulfill your request. All right. Are you enjoying this? Oh, who said attending lecture is something enjoying, isn't it? Attending a lecture is never enjoying. Okay, something enjoyable, right? Okay, but I just want to know that you are at the end of the line there. Okay, so that you are still listening to me. How's wow? Suddenly the number goes the viewer 103. Okay, I don't know. I only share the link for this live with my student. Okay, but soon seems like the number had increased to 100. I suppose that there are other students from other groups or even the PLK student. If they are outsiders, you are welcome. Okay. Also, and if you are not from Malaysia, okay, be mindful that the live lecture I'm delivering at this point of time is as regard to Malaysian contract law. And you are, if you are not from this jurisdiction, okay, I should think that you exercise care a little bit in your understanding or on application of the principle of the law. All right. But again, wow, suddenly it dropped from 100 to 75. Okay. 25 people suddenly disappear. Anyway, it's okay, fine. Okay. I'm giving warning just now to the audience who are not from Malaysia. Okay, that you should be mindful a little bit and extra careful that what I'm going to teach is the position of the law of contract here in Malaysia, not in your jurisdiction. But if you are from any Commonwealth country, okay, I suppose that if you are from the Commonwealth country, you would actually have your Contract Act or contract enactment or contract law impari materia with our Contract Act 1950, okay, because these are all the codification of the common law principle. Right, let us continue. Okay, so what is the effect of a entered by a minor, a person who had not attained the age of majority, a person whose age is below 18 years old? Right. There had been a lot of judicial precedences on this point, but I need to mention one, okay, decision of a Privy Council decision, an appeal from India, which is based on Indian contract law, which is impari materia with our Contract Act 1950 in Malaysia. The case is the case of Mohari Bibi and Dormodas Gaus. Okay, Mohari Bibi and Dormudas Gauss. So you can find, okay, this case in any references or in any material, okay, concerning law of contract of Commonwealth country. But if I did not pronounce it clearly, or if you did not get what I said just now, okay, I have shared you the name of the case and the citation of the case. It's actually a 1903 case reported in the Indian Law Report, okay, volume 30. All right. So basically, in this case, I will just mention, okay, the decision of the court, okay, just to show, okay, what is the outcome of this hearing before, or this appeal before the Privy Council. In this case, the court has held that, okay, a contract entered into by a minor is void. And since it is void, it has no effect. And since it has no effect, it is not enforceable in court. So the Privy Council held that the court cannot upheld, okay, a contract which is entered by a minor. So that is an Indian case. Okay, as I mentioned just now, since the provision relating to the Indian law is in pari materia with our Section 10 and Section 11, okay, we can use this case as an authority. But in Malaysia itself, we have our own decision. The court in Malaysia have had the opportunity also to decide on the issue of whether a contract and what is the effect of a contract entered by a minor. Right, the case is the case of Tan Hee Juan and Teh Boon Kiat. Okay, Tan Hee Juan and Teh Boon Kiat. Okay, this case was reported in the year 1934 in Law Journal, Malayan Law Journal, okay, at page 96. Okay, if you want to have the full report, you can always go to the any law library in Malaysia, okay, and look for Malayan Law Journal, MLJ, okay, and go to that particular page 96. You will get the full report of the case, right? So what happened in this case, right? So basically, in this case, a minor had entered contract, okay, The effect of the contract entered by the minor was to transfer two pieces of land in Mentakap, okay, to the defendant. Right, the execution of the transfer was completed, meaning that the land is now registered in the name of the defendant. On the document of title, the defendant name had already been put there to place, whatever name that was earlier. So subsequently, the plaintiff applied to the court to set aside the transfer, and the plaintiff wants, that this land to be reinstated in his name. So basically, in this case, the court has the opportunity of determining what is the effect of a contract entered by a minor. The court looked at Section 10, okay, that talks about the age competency. The court also look at Section 11, saying that the age of competency to enter into a contract in Malaysia is 18 years old, according to the age of majority Act 1971, and applying the principle in the case of Mohari Bibi and Daramoda Gauss, the court came to the conclusion that the contract entered by the plaintiff at the time when he was a minor, is void and has no effect. And subsequently or consequently, the court ordered the restoration of the property to the plaintiff's name. So there you are. Section 10, Section 11, the case of Mohari Bibi, as well as the case of Tan He Juan and Tibu Kiat as the authority, to support the argument that a contract, is valid if only the parties to the contract had attained the age of majority, and the age of majority here in Malaysia is 18 years old, right? Okay, do you need any further elaboration? If you don't understand, do not worry. Ask in the chat live, box, that I would appreciate or understand, that you do understand what I've been talking about for the past half an hour, or give me some sign whatsoever, either for me to continue or for me to repeat or explain back what I've explained earlier. Okay. All right. Thank you very much for responding. Okay. You are a great audience. Okay. This is what I want. Okay. So far, but I only have 13 thumbs up. Okay. 97 audience at this point of time. All right. So how's the graphic of my video? Should I increase the resolution or should I maintain the resolution? Because I'm using the lowest resolution, available to enable you to have a free streaming compared to if I try to use a higher resolution. So should I maintain, same resolution or a lower resolution? If the graphic is not very good, then my next session probably I will change the resolution to a better resolution. Okay, maintain. All right. Okay, thank you very much, Irudina Shafika. Right. Okay. Right. Let me just continue. Okay. I myself is not satisfied because it's not HD. Okay. So anyway, tak apalah ya, kita kena bersyukur dengan apa yang kita ada. For those who are not from Malaysia, I'm using a combination of English and Malay in my lecture. So I do hope that you can bear with me if I use bahasa Melayu or Malay, in the deliberation of my lecture. All right? Okay, let us continue. Now, does this mean that every time a contract entered by a minor is void? Are there circumstances when a contract entered by a minor can still be enforced in court? Well, There's no general rule that goes without an exception. For every general rule, there will be an exception. The same with the principle relating to the capacity to enter into contract must be by a person who had attained the age of majority. That is only a general rule. There are certain exceptions, and when this exception apply, if the circumstances under which this exception applies, the contract entered by the minor is valid and enforceable. All right. So bear in mind what I'm going to tell you after. These are the exceptions to the general rule. So under these exceptions, even if the contract is entered by a minor, the court can still enforce it against the minor or against the other party, right? So there are a number of exceptions. There are five. If you want to name them or if you want to number them, there are five. The first exception is the principle under the common law. This is what we call contract for necessaries under the common law, or contract for necessity under the common law. This is a principle under the common law. All right. And as you know, if you are my student or you are from Malaysian, by Section 3 of the of the Civil Law Act 1956, and by Section 5 of the same Act, Malaysian courts are allowed to use the common law principle. All right, but we are not going to indulge into that at this point of time because I've covered it, in the topic of Malaysian legal system previously. Though that we do not have it live, but those who had attended my physical lecture would actually understand and appreciate it. So the contract for necessaries under the common law. So what is the principle of law on this matter? Under the common law, a minor is liable on contract for necessaries. Contract of necessaries or contract for necessities means a contract for the supply of goods or services which is necessary and reasonably suitable to the life of the minor. If you want to detail out what are goods and services which is necessaries and reasonably suitable to the life of the minor, it is very difficult for you just to say like food, a roof, clothing, training, etc. are necessaries. Because what are necessaries must be also relate to whether the goods or services is suitable to the life and condition of the minor, right? So, and this can be seen in many cases. Among the cases, the case of Peter Fleming, a very, very old case. But if you cannot hear that, again, I can share with you, the name of the case. Okay, on the live chat box. Peter and Fleming. If you use any material whatsoever, I'm sure that if the basis of the material is the common law principle, you would actually come across this case. In this case, the court held that the word necessary, perkataan necessary, is not confined to an article necessary to support the life of that minor. Right? Mind again. The word necessary. What is necessary? All right, does not depend on whether the article, is useful to support the life of the minor. Okay. Okay. Right. It must be something which is reasonably fit to maintain the minor, a particular person, in his station in life. So that is why you cannot exhaustively say food or clothing or training, or a roof, are necessary. all depend on whether or not those, okay, things or articles or services that had been supplied to the minor, okay, is something suitable to his station in life. If it is not suitable to his station in life, then even though that the good may generally be necessary or of necessity, but it is not suitable, okay, in that particular person station of life, right? Okay, let us look at one case. Okay, probably you can understand how this principle works. The case is the case of Nash and Inman. Right, I will share with you. Okay, the name of the case and its citation. Okay, this case was actually decided by the common law court. Okay, in 1908, volume 2, King's Bench, page 1. Okay, what happened in this case? All right, I'm not going to share with you the fact of the case in the live chat. Okay, but I'm just going to tell you, just like telling any story. Okay, in this case, the plaintiff was supplied by the defendant. Okay. No, let me just put it another way. Okay. I put it wrongly. In this case, the plaintiff had supplied the defendant. The defendant is a minor. Okay. The defendant was a minor. And the plaintiff had supplied the defendant, okay, who is a minor, who studied in the University of Cambridge, 11 pieces of summons suit. Okay, 11 pakaian musim panas. Okay. And the defendant does not want to pay for the price of those summer suits. And the argument put forward by the defendant says that he was a minor. And according to the common law principle, a minor has no capacity to enter into a contract. So the contract entered by him with the plaintiff was null and void and unenforceable. Right, to determine whether on and okay, forgot to tell you that the plaintiff argued that this is not only a contract entered by a minor, but it was a contract for necessaries. Okay, ia adalah satu kontrak keperluan. Okay, so which does the court sided this case. Okay, in this case, the court held that a minor is like a lunatic. Just like a lunatic, a minor is incapable of making a contract. Right? The court recognized that general principle. However, the court continued to say that, but if a man had satisfied the need of the minor or a lunatic by supplying him with necessaries, the law will imply an obligation to repay him for such services so rendered, and will enforce the obligation against the estate of the infirm or the lunatic. All right. So the court said that, yeah, there is an exception. If you had supplied, okay, a minor or lunatic, something which is necessary, okay, to him, okay, suitable to his condition in life, okay, the person who had so supplied him with such goods or services must be reimbursed. However, the court has to test, okay, in every situation whether, okay, this minor is in really need of those summer suits. Because the key is what was supplied must be suitable to his condition in life or, okay, among the society he moves. Right? So in this case, the court says that since the minor in this case had been sufficiently supplied by his guardian an additional summer suit, dia dah ada pakaian-pakaian musim panas yang telah diberikan oleh penjaga dia. So, okay, the supply of more summer suit is not suitable to his condition in life. So the court in this case say that even though that there is a principle that if you had supplied a minor with goods and services which is necessary, it must be suitable to his condition in life. And since in this case it was not, okay, then okay, the contract cannot be enforced against the minors. All right. So basically, not in all situations when somebody has supplied a minor with goods or services, okay, can claim that the goods and services is necessary, okay, to the minor. So saying roof, food, clothing, education per se is not sufficient. It must be suitable to his condition in life. Okay, in the station of life that he moves in. Okay, kalau dia anak orang kaya, okay, adakah suitable untuk dia? Kalau dia anak orang miskin, adakah it's suitable? Okay, so untuk anak orang miskin, kalau dia order Mercedes, for example, it may be necessary to take him from one place to another. Okay, but is it suitable in his condition in life? Okay, because he was actually the son of a pauper. All right. But if he is the son of a wealthy millionaire, okay, and in the level of the society, he is at the upper level, probably, okay, a Mercedes would actually be suitable to his station in life. So you don't test by looking at what was supplied, you test it by looking at whether or not it is suitable to his condition in life. Right? You understand that? Okay. All right. Okay. There's nothing there. I thought there's something there. You want to ask something? Are you all still with me? 78 audience so far. 78. Okay. Keep coming in and going out. Probably the Wi-Fi problems. That's why I always advise be at a place where okay you know that okay coverage is good. Okay, if not, we may have to actually have the session okay face to face. Okay, as you know, we have the session online because we want to support the effort of the government to reduce dependency on fossil energy, because now the price of the fossil energy, which is okay now other than petrol or diesel, has gone up since the issue between Israel, America, and Iran is not settled at this point of time. So let us support okay, the effort of the Madani government. Right. Okay. Any question on the first exception? Okay, contract of necessities under the common law. Okay, but we are far from finished. Okay, I just want to mention what are the requirement okay that must be established before one can say that a contract okay to supply a minor okay for something which is necessary to his condition in life okay can be enforced against the minor. All right, so in fact there are three conditions. Okay, one, the goods and services were supplied or rendered, meaning that okay, based on the contract, the minor had been supplied okay with the goods or services. If the good had not been supplied, okay, if it is only a promise, okay, and another promise, okay, consideration has not passed, right? In such a case, if the goods had not been supplied, then there is no obligation on the part of the minor to reimburse, okay, the person who had so supplied the goods or services to him, because it had not been supplied. Yang penting barang atau perkhidmatan itu telah dibekalkan, bukannya belum dibekalkan. Itu syarat yang pertama. Okay. The second is that the goods and services were necessaries. Okay. The goods and services were necessaries. Okay, right. But whether or not the goods and services were necessaries, it depends on whether the goods and services is suitable to the life of the minor. All right. So these are the three things, three tests, okay, that you have to use before you can apply this exception. Right? Okay. Anybody want to ask anything? Okay. Say something. Okay. Or if not, forever it will be forgotten. Okay. Let us continue. Let us look at the second exception. Okay. Right. The second exception is provided by Section 69 of the Contract Act. Okay, Section 69 of the Contract Act. I hope that you have the Contract Act with you and you can refer to Section 69 of the Contract Act. Okay, let us title this exception. Okay, this exception is what we call contract for necessaries. Okay, so the title is the same as the first one, but okay, this contract for necessaries, okay, is a written law as provided by Section 69. Okay, so what the Contract Act 1950 did was, okay, to codify the contract of necessaries under the common law. So the Contract Act, okay, codify the contract for necessaries under the common law, okay, into Section 69. So let us read Section 69. Okay, according to Section 69, if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suitable to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So, right, so that is section, okay, 69. So if you notice, this principle is similar to the contract for necessaries under the common law, except for that it is now codified. It had been made as a written law in section 69. Okay, jadi mengikut section ini, jika seseorang yang tidak layak untuk berkontrak ataupun mana-mana orang yang seseorang itu bertanggungjawab untuk support ataupun untuk tanggung, telah dibekalkan oleh seorang lain, okay, dengan keperluan yang sesuai, okay, kepada keadaan kehidupan orang itu. Okay, orang yang telah membekalkannya dengan keperluan itu hendaklah diberikan pampasan daripada harta orang yang tidak layak tersebut. Alright, so if you actually direct translate it, no doubt, no problem, you can really cut and paste and put in any AI search, okay, and ask them to translate it to the most simple word. So basically, the Contract Act 1950, okay, had codified the contract for necessaries under the common law. All right. However, Section 69, nor the Contract Act 1950 had give any definition of necessaries. Okay. Akta Kontrak tahun 1950 tidak memberikan tafsiran apakah yang dimaksudkan dengan keperluan. Okay. Thus, for this, we have to see also the definition under the common law. Okay, so the definition of the common law is used also to give meaning to what are goods and services which are necessaries, and it is the same. Okay, the judicial precedences on this point had said that for goods and services to be necessaries, it must be reasonably suitable to the condition of the life of the minor. If it is not, then Section 69 will not apply. So the same definition as what was offered in the case of Nash and Inman, and the case of Peter and Fleming. But at least in Malaysia, okay, the Malaysian court had one opportunity to define, okay, one services or good as necessaries or necessities, okay, and this is concerning to a scholarship contract. Okay, this was decided in the landmark case of Government of Malaysia and Gucharan Singh. All right, so I'm sharing with you in the live chat. Okay, the name of the case. Okay, Government of Malaysia and Gucharan Singh, 1971, Volume One, Malayan Law Journal, page 211. Okay, so what happened in this case? Okay, in this case, the respondent was awarded, Gucharan Singh was awarded a scholarship to study at the Teachers Training College. Right at that time, he was about 17 years old after finishing his MCE, or now Sijil Pelajaran Malaysia SPM. Okay, around that age. Okay, and we know that 17 years old is a minor. He had not attended age of majority. Just finish his MCE, okay, which is equivalent to SPM now, okay, and he signed an agreement, a scholarship agreement with the government of Malaysia, that the government of Malaysia is going to support him to study in the Teachers Training College. Okay, there was a term, okay, in the contract that says that, okay, Gucharan Singh has to serve as a teacher after completing his study. So I think he studied there for 2 or 3 years, and he graduated as a teacher, but he refused, okay, to serve as a teacher in the government school. Right. So what government of Malaysia did was actually to sue him for breach of contract. And Gucharan Singh, okay, probably he's trained or the lawyer assists him. The argument was that at that time when he enters into the contract, he was a minor. He had not attended each of majority. He was around 17 years old. So the contract entered by the minor was null and void. But okay, the government of Malaysia argued that this type of contract falls under the exception, and as a scholarship is a contract for necessaries. Okay, and for this the court, okay, this case go as high as the Privy Council. Okay, in England, Privy Council is then, okay, the last appellate court, okay, for the Commonwealth country. So the Privy Council in this case, okay, in trying to determine whether or not should now Gucharan Singh be bound by the contract with Government of Malaysia, okay, has to consider whether or not the scholarship contract, okay, is a contract for necessaries suitable to the condition of Gucharan Singh at the time when he enters into the contract. So the test of necessaries, okay, was used. Right? And the court in this case concluded that, okay, by the nature of the goods or services, which was the scholarship supplied to Gucharan Singh, the court came to conclusion that it is suitable to his condition in life. As I said just now, he was 17 after leaving his Form 5, and he was looking for an opportunity to be trained so that he get skills and knowledge for him to use in the future. So that is very important, okay, to him. So the court says that the scholarship was goods or services which are necessaries and suitable to his condition in life. So the court said that, well, Gucharan Singh is bound by the contract, even though that he was a minor, okay, by using Section 69. All right. But again, from this case, the three, okay, condition, okay, must be fulfilled. First, the goods and services were supplied or rendered. Okay, telah dibekalkan. If it had not been supplied, fine, the minor is not liable. Two, the goods and services were necessaries. And three, whether the goods and services were necessaries, you have to use the test whether it is suitable to the condition of the life of the minor. Right? So this case laid down a principle that a scholarship is or was a goods which is necessaries. And if it is entered and a contract entered by a minor to be supplied with scholarship, okay, it binds the minor and it can be enforced. Right? Okay, so that is the second exception, or the third exception, sorry. Was it a third or second exception? Second, I suppose, if you want to count. First, contract for necessaries under the common law. Second, contract for necessaries under Section 69. All right? Now, the third is a scholarship contract. Okay. Some of you may think that what is the difference between the third and the second? One of the decided cases, the case of Government of Malaysia, that scholarship is a contract of necessaries. Okay? Okay, let me just explain. All right. What happened after, okay, the decision of the court in the case of Government of Malaysia and Gucharan Singh? Okay, after that case, okay, the government become worried that, okay, there may be a case after the case of Government of Malaysia and Gujarat Singh where the government enter into a contract with a minor, okay, for a scholarship, but it is not suitable to the condition of the life of the minor. Apa kata kalau, okay, ada perjanjian yang dibuat oleh kerajaan dan seorang remaja untuk beasiswa, tetapi remaja ni yang sebenarnya tidak memerlukan scholarship itu. Okay, mungkin dia daripada, he came from, okay, an upper class, okay, in the society. Okay, scholarship is not important to him as the parent or the father can actually send him abroad to study whatever discipline that he wants to study. All right? He probably just want, okay, to follow his girlfriend. I'm just exaggerating lah. The girlfriend also went to teachers training college, okay, and he also want to go there just to be there with the girlfriend. Okay, in other words, it simply means that the scholarship is not necessary for him. So if you have to use the test whether it is suitable to his condition of life, then, okay, it is not certain that every contract entered by a minor, especially scholarship contract entered by the minor with the government, okay, is enforceable. So that was why the Contract Act 1950 was amended. It was amended, okay, by the Contract Amendment Act 1976. All right, so in 1976, the law has changed a little bit. Okay, the act is also known as Act ACT 8329. And I just, even though that there are many provisions, just to sum up so that to make it clearer, under Section 4 of the Contract Amendment 1976, any scholarship agreement made by a minor with the federal government, with the state government, with any statutory authority, and with any approved educational institution. So if the government enters into the contract, I'll just lump up these four categories of institution. 1, federal government. 2, state government. 3, statutory authority. And 4, any other approved educational institution. Okay? The contract, scholarship contract, shall be valid, notwithstanding the scholar is not of the age of majority. So in short, now, if a minor entered into a contract for scholarship with the government. I used wanted to describe the four entities just now. Okay, so a minor who enters into a contract, okay, with the government, and the contract is a scholarship contract, it is enforceable against the minor. Okay, so for this, there is no necessity or not to determine whether scholarship, okay, is necessary or not necessary to the condition of life of the minor. Okay, so long as if it is a contract of scholarship entered by between the government and the minor, then the contract is valid. Tak perlu nak uji. Okay, I'm repeating in bahasa, okay, in Malay. Tak perlu nak uji sama ada dia necessary ke tak, sesuai ataupun tidak dengan kehidupan mangsa, kehidupan remaja tersebut. Right? So that is insofar as a contract of scholarship entered by a minor with the government. Now, can probably it come across your mind. What if the contract is a contract made between a non-governmental institution, okay, and a minor? Okay, what is the effect of this amendment to such contract entered between a non-governmental institution? Because that's now section 4 only talk about governments, isn't it? Scholarship contract between minor and government. Okay, so now the question is, what if the contract is a contract between a minor and some non-governmental institution or entity? Now, for this type of contract, okay, non-governmental institution, okay, we still use section 69 or the common law principle. It is necessary for us to determine whether the goods or services is suitable or not. It must be depending to the station of life of the minor or the society where the minor moves in. Right? So that is the third exception. Right? Any, do you understand? We are going to look at some other exception, but so far we have three. One, okay, contract of necessities or necessaries under the common law. Two, contract of necessaries under section 69. And three, scholarship contract under section 4 of the Contract Amendment Act 1976. Okay, so shall I proceed or shall I not? Give me a sign. I'm sure that I have about 80 audience. Okay, I dropped 79. There must be somebody there that really listen to what I'm saying. All right, thank you for the sign. All right, put a comment if you want to put a comment. You are welcome to put a comment, good or bad. I accept. Okay, it's just information for me to improve myself. All right. Okay. Thank you very much for responding. Now, let us look at the fourth and the fifth exception. Okay, where contract entered by a minor is valid. Right. Okay. The fourth is insurance contract. Okay, insurance contract pursuant to the Insurance Act 1963 that was revised in 1972. A minor between the age of 10 and 16 may enter into a contract. Right? So the contract for insurance entered by a minor is valid, but there is actually a condition there. It must be consented by their parent. Right? So that is insurance contract. And lastly, the fifth exception where a contract entered by a minor is valid, okay, is under the Law Reform Marriage and Divorce Act 1976. Okay, The act is known as Law Reform (bracket Marriage and Divorce Act 1976). According to this act, for the non-Muslim, okay, who is below 18 years of age, okay, they can enter into a marital contract provided with the consent of their parent. So basically, even if a person is not of 18 years old, he can, okay, marry another person, whatever age that person would be. Okay, the contract, though that entered by a minor who had not attained the age of majority, is still valid and enforceable. So there you are, okay, principle as regard to competency in terms of age and the general rule and the exception. Remember, just to recap back, one, a contract entered by a minor is void. However, a contract entered by a minor under five circumstances. One, okay, contract for necessaries under the common law. Two, contract for necessaries under Section 69 of the Contract Act 1950. Three, okay, contract of scholarship under Section 4 of the Contract Amendment Act 1976. Okay, that is three. Okay, all right. For insurance contract, okay, under the Insurance Act, and five, marital contract under the Reform Marriage and Divorce Act 1976. All right. So those are principles as regard to, okay, competency in term of age. Right. There are two other competency just now, okay, that I mentioned, which is the requirement of Section 10. Okay. Right. We have talked about age as one of the elements of competency. Okay, then the second one is mental competency, and the third one is legal competency. Right. Now let us look at capacity to enter into contract insofar as mental competency is concerned. By Section 11, okay, of the Contract Act 1950, parties are competent to contract only one, he had attained the age of majority just now. We have mentioned, we covered that in the earlier session. Only who are of sound mind. So a person, okay, is said to be mentally competent to enter into contract if he is of sound mind. So when is a person is said to be of sound mind? Okay, according to Section 12, I hope that you're going to read that with me now. Okay, Section 12, subsection 1. If you have the Contract Act, you can flip, okay, very fast. Okay, subsection 1 to Section 12 is that a person is said to be of sound mind for the purpose of making for making a contract. Okay, if at the time when he makes it, he is capable of understanding and forming a rational judgment as to its effect upon his interest. So basically, the test is very simple. At the time when you make the contract, do you understand, okay, what you did? And you can rationalize that what you did would affect your interest. If the answer to that question is yes, then you are mentally competent to enter into a contract. Okay, and you probably ask, what if a person, okay, he goes in and off from the soundness of mind? Okay, according to Section 12, subsection 2, it says that a person who is usually of unsound mind, but occasionally of sound mind, may make a contract when he is of sound mind. So if you goes in and back being time when he makes the contract, was he of sound mind? Right? If at that particular time understand and can form a rational judgment as to the effect of making that agreement to his interest, then he is of sound mind. If it is otherwise, then he is not of sound mind. So that is mental competency. Okay, and the third, okay, I think that will wrap up our life today is as regard to okay legal competency. Sometimes there are laws okay that disqualify us okay to enter into a contract. One of the act is, let's say, a bankruptcy act. A bankruptcy act is an act that give the court power to adjudicate a person to be a bankrupt. What okay does it mean? It simply mean that a bankrupt is a person who is unable to uh, maintain his own affair, to the extent that his affair is taken away from him and his affair will be in the hand of the government, okay, through what we call the insolvency office. So a person who is a bankrupt is not competent to enter into a contract. So this is what we call he is disqualified by the law to enter into a contract. So there you are, three elements of competency which has to be satisfied, okay, to make an agreement contract a contract. So I do think that that actually wrap up our session today. Okay, do you understand or do you want to ask any question? Please go ahead. I can still give you time. Probably this is a Q&A session of this live lecture. Nothing. All right. So if you have nothing to ask, then thank you very much. That will be all for our session today. Until I meet you again, aku qawli hadza wa billahi taufiq wa hidayah. Assalamualaikum warahmatullahi taala wabarakatuh.